France tuh by the time itu tuh kayak France udah kayak completed and kayak nggak ada intention to kayak conduct further tests, but they did in the 1995 if not mistaken. Terus udah sih kayak the difference between the Australia claim and New Zealand claim is that the Australia focuses more on the kayak Australia tuh lebih fokus ke atmospheric nuclear test, tapi kalau New Zealand itu kayak lebih kompleks gitu deh.
So
there are several principle, however, because the judge itu nggak nge-judge principle, nggak nge-judge kayak tentang the merits of the case, therefore kayak saya imply di sini kayak beberapa principle which might be applicable, yaitu ada sic utere tuo ut alienum non ledas atau transboundary harm. Itu obligation not to cause injury to or within another state's territory. Terus good faith principle. Itu in performing legal obligation, it shall be carried in an honest manner. Terus precautionary principle. If any strong suspicion that certain activity may harm the environment, such activities shall be controlled immediately rather than wait to incontrovertible scientific evidence. And erga omnes. And this principle is applicable for both Australia's claim and New Zealand's claim.
Okay. So why do you think these principles are important in terms of resolving the case?
Resolving the case claimnya. Because if I'm not mistaken, kayak the judge itu nggak nge-adjudicate merits-nya, terus kayak I found this principle kayak dari dissenting opinion sama kayak journals gitu sih, ma'am.
Okay,
kayak,
but specifically
whether it is applicable for our case or not.
Specifically for this case, I think I'm gonna call upon Alia. Are you there? Alia Latifa Sofian.
Yes, ma'am, I'm here.
Okay, so what do you think, Alia? Why the principles that Harviana discussed earlier is crucial for the specific nuclear test case?
Based on
in here, in your extra credit, you were talking about precautionary principle, right? Can you just elaborate precautionary principle in the case? Why is it important?
This is the Lake Clonox case, right, Miss?
No, the nuclear test case.
Okay. Because what New Zealand and Australia did was a precautionary, an act of precautionary, so that further damages wouldn't happen. So their their demand was that based on something that they thought would happen in the future if this is continued. So it's an act of precautionary. That is as far as I understand it, Miss.
Okay, and then you also talk about prevention principle.
Okay, so wait, suspicion, environmental harmful is better to control. Precautionary, so that it won't damage the damage won't be incontrovertible. However, for the prevention, it is because it would be cheaper and easier to mitigate rather than to wait until for it to happen. Are you asking for the difference, Miss?
Yeah, I'm asking because you're mentioning both of them, and then you sort of not give elaboration why why is it there in the list? Both the principles, why are they there?
I think what I used as like deliberation is that
Mm-hmm.
precautionary situation, it is kind of harder to calculate the risk com rather than prevention, Miss.
Okay. Okay. Thank you. Let's okay, thank you. What's your name again? Now I'm lost.
Alia.
Okay, now thank you, Alia. Now I'm calling on Owen. Are you there, Owen?
Yes, ma'am.
Okay, can you help out Alia and Harviana on this? Specifically, why the principles that Harviana discussed earlier are important for the nuclear test case of 1974.
Mm, I mean, it is important because it is useful so that the French are in the future or other countries in the future doesn't do what the French did during the 73 and 74.
Okay, what did they do?
I mean, in the 73, I mean, like the nuclear test case, basically they drop atmospheric nuclear tests on top of like French Polynesia, which is located in the South Pacific Ocean. And it's quite close. The location is quite close with Australia and New Zealand, and therefore that's why the Australian government and also the New Zealand government are requesting to stop the atmospheric test because
Right,
they're afraid that the fallout will reach their country and affect the health of the people.
right. So both Australia and New Zealand are enacting precautionary principle and prevention and protection on the environment, right?
Yes,
And then what do they ask France to do?
to stop further testing of
Okay,
atmospheric nuclear testing. Yes.
yes, but based on what principle?
I think the principle you just mentioned, the preservation and protection of the environment, and also my case probably also responsibility not to cause environmental damage and good neighborhoodness.
Okay, so responsibility not to cause environmental damage and good neighborhoodliness and avoiding transboundary harm to
Yes.
other countries. Yeah.
Yes.
Okay. So I'm hoping everybody else can also follow the discussion because I think like 30 of you already submitted extra credit on this specific issue. So I'm hoping, even the ones who are not doing extra credit can also chime in, yeah, on our discussion. So we're discussing two cases today. First one is the nuclear test case, Australia, New Zealand versus France. The second one is on Lake Lanu arbitration case, right? So, but okay, so we were just like suddenly dwelling in on the cases and not giving you background information on this principle of international environmental law itself. So, the principles of IEL is specifically the backbone of IEL because it gives a platform as where IEL can stand on. So there are so many principle of international environmental law that has been adopted into other parts of international law because it's so useful and it's just over encompassing so many things which helps judges and also prosecutors and lawyers to sort of articulate what they need to articulate in terms of adjudication of cases. So okay, so we'll start. Wait. Okay. We'll start on the several principles that you guys have already iterated for the nuclear test case. Okay, can you see my presentation?
Yes, Bu.
Okay, so these are just a few of the principles that are existing in IEL. The most used ones. There are many other ones, as you see in Philip Sand's book. But at least if you already taken international environmental law class, I want you to be familiar with the ones that we're discussing here. So the first one, I'm sure you heard it, somewhere, is the polluter pays principle, right? It is a principle that specifically say if you pollute the environment and then you have to pay for it, right? The cost of pollution, prevention, control, and reduction measures are to be borne by the polluter. So it's not the responsibility of the people who are the victim of pollution or the government or other parties, right? But it is borne by the polluter, right? The principle obliges the polluter to incorporate the cost of pollution control in its own costs to internalize them. So you haven't seen this in Indonesia, but if you go to Japan, for example, and if you buy, you go to Akihabara and then you buy electronic stuff, whether it is a laptop or a phone or a computer, a PC, they already have what they call, polluter charge for the product, for the e-waste. So they already calculated, for example, if it's a phone, they already calculated how much it would cost to manage the waste of this electronic product later on when it's not being used anymore. And then they somehow, because they got charged, by the government to manage the electronic waste in the end, so they charge, the customer also with, a paying price of taking care of the e-waste. E-waste is another problem because in Indonesia, I can ask you now, where do you put your old phones? Do you discard it somewhere or just put it in the drawer somewhere? Right? Because it's not, you don't have like a place where you put your e-waste. Even like in school and campuses, when they have old monitors or old PCs, they just strap it and take all the still valuable metals, but then the rest is, they go to just to regular solid waste dumpster. So yeah. So just for example, that how polluter pays principle is one of the most used principle in international environmental law. Also, if you look at cases such as the BP oil spill in the Gulf of Mexico, and you'll see that this principle is being brought up a lot because you were the one who pollute, you need to clean up, you need to pay the cost of repairing the environment, back to where it was before. Okay. Any questions on PPP, polluter pays principle? No? Okay, I need everybody to be very familiar with
I apologize,
this.
ma'am. I have
Okay.
a question if it's allowed.
Who is this?
Ardi Muhammad Ardian Syarifin.
Okay, go ahead, Ardi.
Yes. What does it mean to internalize them? Do they somehow swap the like integrate the cost into, for example, maintenance or operational costs?
That's why I give you the Japanese e-waste cost, right? It's internalized into the price of their product. So they already calculated everything, including how to manage the e-waste later on, even though the product is still new. So they're selling it with a caveat in mind that they will pay for the product's waste management. So that's called internalization. You add up, you add not just the production cost, not just the distribution cost, not just the packaging cost, but including the possible management of the e-waste later on.
Oh, I understand. So it's basically the product cost markup, product price markup.
Yeah. So, well, not markup, but like sort of breakdown of whatever it is. So you don't just calculate, because like right now you calculate everything, but you don't think about what you would do to the product later on, right? You don't know, you don't care actually where your PC would end up if it would, if people stop using it. So in Japan, they already did that. So that's how they internalize their product e-waste cost into their production cost.
I see very well. I understand now. Thank you,
Okay.
ma'am.
All right. Other questions? No? Okay. We'll continue with the second principle of sustainable development. I am pretty sure most of you have already heard this. I think we discussed this last week when we talked about WCN, when we talk about Stockholm Declaration, right? So, and also the Brundtland Report of Our Common Future. This is a principle that highlights the development that meets the need of the present without compromising the ability of future generations to meet their own needs. So you do develop your environment, but you take good care of it, so much so that the pollution doesn't burden the environment so that it cannot perform for the future generation. So this is when, when there were, when the world was full of developing activities and, getting more and more profit and boosting economy, etc. And then they forgot about environmental conservation. And then the movement at that time was environmental conservation. They wanted to conserve the environment so bad. So stop all development activities, nobody was allowed to do anything, just keep the environment as pristine as it is. So, and then people come up with this third way. Anthony Giddens from London School of Economics wrote a book called The Third Way. And then the Brundtland Report made a report called Our Common Future, which also talks about this, how we develop our environment, but we don't compromise it so much so that it cannot function. Okay, sustainable development. Any questions?
Ma'am, I'm sorry, but I want to ask about polluter pays principle, if I may.
Okay, who is this?
Refino, ma'am.
Okay, Refino, go ahead.
I was just wondering, does in that principle, does the polluter have to pay in like a monetary value? I mean, what happens, if the damage is, irreversible and it cannot be reversed through compensation, even by money.
Okay, so the well, it's not the problem actually. The dilemma in PPP, polluter pays principle, is when the damage was so big and that nobody can do anything about it, or it seems like nobody can do anything about it, like the BP oil spill, or like a tanker being shot and then it blew up and the oil went everywhere, and there are so many biota died, birds, fish, seaweeds, and fishermen losing their livelihood, etc., etc. So how do you calculate all of this, right? Actually, there are like in environmental economics, they have some sort of measurements tool on how to evaluate these things, right? Like, you know, how to get the ocean water back to its, you know, original state before the spill. You know, how much do you have to pay for it? And then for the fishermen who lost their livelihood, they can calculate how much is he catching per day, and then how many days he has not been able to, you know, get get harvest from the ocean, etc., etc. And then for the biota that died, they can calculate, you know, like roughly, right? It's an approximation. It cannot be like the exact thing. So, but the highlight of this is that they want to be sure, like international environmental law wanted to be sure that the polluters will have to pay damages, that they have to be responsible in a way. If they cannot pay in monetary value, they have to be able to reverse, to restore the environment as if it did, you know, the accident or the pollution didn't happen. You know, it's somehow very mind-boggling, right? Because like in Indonesia, it's something that we almost didn't never hear. Anybody heard about the Lapindo mud case in Sidoarjo?
Yes, ma'am.
Yes, ma'am.
Especially from Surabaya.
Okay, so you know what's going on, right? So somehow said, you know, some people said it was an accident, some people said it was like a natural disaster, and then suddenly it became opinion war between, you know, the corporation and the people there. And then the case just went forward until somehow the state decided that it was a, you know, it was a natural disaster. So why was it important that the state decided it was a natural disaster? Because in order to access the budget for victims, the state budget for victims, the state, in this case the president, have to declare that what happened was a natural disaster. Once it was just declared that it was a natural disaster, then like the governor, the district head, you know, the kecamatan kepala desa, they can act and, you know, start doing you know, all kinds of help that was needed by the victims. But also by declaring that it was a natural disaster, it sort of scratched the polluter pays principle of the international environmental law from the hand of the corporation. So yeah, so that's, you know, so who's paying for it? The Lapindo mud? All of us, because we're paying it with our tax money. Yeah. Okay. So we continue to this one. I think Alia was discussing this, right? The preservation and protection of the environment. So this was involved, these principles were somehow involved in the first case that we talked about the nuclear test case in, you know, in the area near to New Zealand and Australia in the Pacific Ocean. So France was doing testing, very high radioactive testing in the area repeatedly. So much so that New Zealand and Australia was thinking, this is going to damage our environment. They're going to kill the fish. They're going to give radiation to, people who are fishing next to the areas, etc., etc. Right? So they invoke this preservation and protection of the environment. Okay, the difference between the two: protection is a general principle which includes both abstaining from harmful activities and taking affirmative measures to ensure that environmental deterioration does not occur. So make sure that you don't do it and you stop whatever that you're doing, right now. While preservation is a long-term perspective which take into account the rights and interests of future generation for whom the natural resources should be safeguarded. So instead of just talking about the current situation, preservation is talking about long-term. It's talking about now and the future. Why? Because we want our children's children to be healthy. We want our children's children's children to still have, clean water without radiation, etc., etc. Okay. Any question on preservation and protection of the environment?
Do I have a question?
Mm-hmm. Who is this?
Brigitte.
Okay, Brigitte, go ahead.
So basically, protection of the environment somehow related to sustainable development, yeah?
Yeah, in a way, because like mostly all the principles are related to one another.
Okay. I mean, like, basically, it sees like for the future. Okay. Thank you.
Yeah. So, Bridget, you will see later on that there are many principles in IEL that concerns the future, because that's what we are worried about in terms of the environment. We already see the damages now, but like in the future, it's going to be worse, right? So that's why there's a lot of a lot of things, a lot of principles that are enforced in terms of safeguarding our future, including this one.
Okay, thank you, Bu.
Yeah, including this one, which is the preventive principle, right? Preventive, prevention, and preservation. And then there's also precautionary. Everything is pre, which means before, right? Which means before. So preventive principle is a golden rule for safeguarding the environment. It requires the state to exercise due diligence, which means to act reasonably and in good faith, and to regulate public and private activities subject to its jurisdiction or control that are possibly harmful to any part of the environment. So it's somehow in Indonesia, when you see preventive principle, you will hear the word AMDAL, analisa mengenai dampak lingkungan, ya. So in international world, they call it AIA, Environmental Impact Assessment. So here is if you were going to build like a factory, right? If you're going to build a factory, you sort of have to know whether the activities of your factory will have an impact to the environment, and how much impact is that? What can you do to reduce the impact or manage the impact? Can you clean your own wastewater? Can you manage your own solid waste so much so that it doesn't burden the environment? Or if there's too much impact and it appears like there's nothing you can do about it, then don't do it. Then the AMDAL or the EIA will not be issued for you, theoretically, right? So this is what preventive principle was supposed to safeguard. So before you do an activity, before you build anything, you have to be sure that you will be able to take care of your activity and the environment surrounding your activity, so much so that it doesn't burden the environment, it doesn't possess harm to the environment. Okay, any question on preventive principle?
I have a question, ma'am, if it is
Mhm.
allowed.
Yeah, who is this?
Ardi, again.
Okay, Ardi again. Go ahead, Ardi.
I have a question. Does this preventive principle could be possibly derogated? Because I think I see some in website, or I think it's in Agrarian Act, that actually it is possible to derogate the preventive principle if the damage to the environment is, let's just say, minuscule compared to the societal and economic benefit of the activities in question. So is that true? Is this preventive principle could be derogated?
So in EIA, in the environmental impact assessment, you sort of have you have a table called the risk factor table. So it's measuring how much risk you and the environment in your surrounding is going to face, right? It's political factor, economical factor, sociological factor, including also environmental factor and hazardous factor like toxic and all that stuff. So is it possible to derogate preventive principle? I hope not, right? But in Indonesia, we also have the social justice principle, which is not an environmental law principle, right? It's called prinsip keadilan sosial tanah. So specifically on the agrarian law, but it's more on giving the rights to access their land, specifically for social justice, right? And it's not directly aimed for pollution or environmental harmful activities. It's more on, okay, so that specific principle that I was talking about, the social justice principle for land, is when when you have land behind some other people's house, right? And then what they have to do is they have to give you access no matter what. At least for you to be able to get into your land. If there is no other way for you to get out from the land or the house that you bought. So they have to make sure that they give you an exit and entryway. So it means when I said they is your neighbor, the neighbor that is closest to the street, to the bigger street. So yes, specifically for that, probably yes. But in terms of other things, in terms of pollution and harmful activities to the environment, I hope the preventive principle is not being derogated. Although in terms of AMDAL, like currently, like in practice, it's always hard to know whether the AMDAL that has been done by corporates are 100% solid anyway, because they're paying consultants, they're paying expert to do it for them. So chances for these experts that are being paid by the company to say, oh, you cannot build your factory is pretty low, right? So we never know whether those AMDAL are 100% bulletproof. Plus the new the new law on Cipta Kerja, I think yesterday it was being enacted, somehow also reduce the importance of EIA, of AMDAL in environmental activities. It's somehow very concerning also. So I don't know, because the law was just enacted yesterday, we don't really know whether this omnibus law would totally can take place and just disregard all the current laws that are already there. But let's see lah. I think we need to amend it so much so that we can still protect the environment. But yeah, so I've been discussing this for a long time, like probably the past 3 months, but people are not, people are just, it's okay, blah, blah. And now they became suddenly aware. It's been there, like the draft has been there for the past 6 months. But because of COVID, everybody else was like busy with everything else. Okay, so other questions on preventive principle?
Thank you, ma'am.
Yeah, thank you, Ardi. Other questions? No? Okay. So now is this one, precautionary principle. So precautionary, like by default, right? When you hear precautionary, you know specifically what to do, right? It's a precaution. You need to be careful. You need to be very aware of what you're doing. But there's no like one definition that would totally tell you what is precautionary principle. But these are like the principles under the precautionary principle, right? Bahwa lingkungan itu rentan, like the environment is very fragile, right? Bahwa if you don't have like current science to predict the danger or the threat to the environment, and that there is alternatives to do your process or product which is safer and more environmental friendly, you have to take that one. Like even though there's no current science that is telling you, okay, it's going to be dangerous for you, but there is a possibility. So precautionary principle is just taking it very slowly, very safely, and trying not to come up with any pollution activities that would be harmful for the environment and for people. Okay. Any question on precautionary principle?
Halo Bu Linda,
Hi, who is this?
this is Adinda.
Okay, Dinda.
So I read in the book that the precautionary principle isn't actually like applied by every country. So it says in the book that the U.S. has a tendency to look at the science more strictly. So I think it's a difference comparing to the EU regime where they apply the precautionary principle. So what do you think about that?
Okay, so EU and the US is, they're both developed regions, right? They're both very developed regions with their own standards and perception on the environment. Somehow, like when you're talking about pollution activities, they both have done it way before 1960, right? The revolutionary industry happened in their area, etc., etc. So, is the US being more careful when we compare it to the EU. I would say I'm not quite sure about it because there are like different activities that are done by the EU that is not done by the US, or done by the US that are not done by the EU. Like, for example, currently, anybody hear about the import of palm oil to the EU is being banned from Indonesia? It's being banned since 2019. The basics, the basic reasoning was precautionary principle, and they think even though palm oil is a renewable energy source, because it's a it's a biofuel, they think that palm oil came from an area where people burn the forest in order to plant the palm trees. So they decided, we're not going to take your palm oil unless you have certification of ABCDE, very complex, very hard for Indonesia or Malaysia to fulfill. Now in 2020, the US is also trying to ban palm oil in 2021. They're saying not because of precautionary principle, but they're saying because that there's no proof that palm oil can compete with other renewable energy sources. So Dinda, if you ask me, I think it's very it's just politics. It's how they carry themselves, playing the good cop, bad cop. So yeah. So I in general, I don't specifically believe that there is a country that is so good-hearted and they want to implement all these principles without thinking about their politics or their economy, and and all these burdens.
Okay, got it. Okay,
Yes,
thank you.
Dinda. Okay. Next one is this one, right? It's still on precautionary principle. It's precautionary approach. It's principle 15 on the Rio Declaration. In order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. See, when there is a lack of scientific certainty. So even if they don't know for sure that, that these countries are burning tropical forests in order to plant palm trees, even though there is no evidence, but they want to play it safe by, okay, we're just not going to buy it from you. Okay. So this one we talked a little bit last week, I suppose, the common heritage of mankind, right? Bahwa kekayaan dasar samudra di dalam samudra adalah warisan bersama umat manusia, right? It's not the same with res nullius or res communis. It's exclusive use for for peaceful purposes, rational utilization in the spirit of conservation, and good management and transmission to generations to come. So, common heritage of mankind is not saying that, because it belongs to everyone, then it doesn't belong to anyone. But it's, for everyone to use. Not just the ocean, I suppose. It's been, also discussed that it also include, like other space objects, and the poles, North poles and South poles. Although, now countries has already began to make their plots in the poles also. Okay, and sometimes we get confused with this other one, common concern of humanity, right? It's actually a very different idea, because common concern of humanity is the general basis for the international community to act. So it's more on action, right? The respect and protection of such concern is legal basis of regulation, which imposes obligation on states, regional or local authorities can limit, when necessary, individual freedoms and rights, but which can also support such right. So this is an alternative to the contract system, and this we see a lot during COVID-19, right? So common concern for humanity currently during COVID-19 is public health. So you see this being used a lot. For example, for harvesting data directly from mobile providers. Well, it's not being used in Indonesia or Singapore or Malaysia, for example, but in other countries they do it because it's easier, rather than asking the mobile users to download, an app so they can trace where they are. Because actually they don't need to do it. They just, go to a provider and ask them to give the GPS location of all their users, which they can. So maybe in those countries, they're using this principle, common concern for humanity, in this case, public health, right? Okay, any questions for these two principles?
Belinda, I want to ask about the common concern of humanity.
Who is this?
Revino.
Okay, go ahead.
Yeah, I just, because you point out that states may ask the provider for the GPS of the citizens, right? So, what is actually, the agenda of the states by doing so?
Oh, during COVID?
Yeah.
Yeah, so they know where they are for contact tracing.
Oh, I see.
Yeah, so I think, if I'm not mistaken, they've been doing it in Israel. So the government know exactly where each citizens are, because everybody's using mobile phone now, and they just ask the mobile company to share the data to contact trace their citizens. So if there's like a cluster, they automatically know who's been there, and how long they've been there, whether they've been exposed or not, like approximately by distance and the length of time that they spend in that place, etc. So yes, it's for contact tracing.
Oh, okay, ma'am. Thank you.
Okay, all right. Other questions? Okay, no other questions. And this one. Okay, CBDR, right? Common but differentiated responsibility. So this is completely different idea from the other commons, the other two common principles that we already discussed. So CBDR is implementation from general principle of international law in terms of equity and acknowledgement for the developing stages of developing countries. So how do we explain this? So we sort of we as in international community, right? So the international community is being separated into stages, right? So we have developed countries, like rich countries that are already advanced in developing activities. And then we have developing countries who are in transition into rich countries, for example, China, and then like Singapore, right? Even Qatar, so Qatar is the highest GDP in the world, but they are still grouped as developing country. Anyway, and then we have, medium level developing country like Indonesia, the Philippines, and then we have the lower level of developing countries, countries like in Africa, so Nigeria, maybe Ghana is there. And then you have like lower income and then like war zones countries. So these levels, and then being projected in this common but differentiated responsibility. It's like saying everybody has the same responsibility, but it's according to their capacity, like how to reach that responsibility is according to that capacity. This was reflected in, for example, Kyoto Protocol, right? We will talk about this in length when we talk about IPCC. But Kyoto Protocol divided the member countries into two annexes. Annex 1, developed country, and the non-Annex 1 country, which is developing countries. So the obligation to reduce greenhouse gases production emission is just for the Annex 1 countries. So they're being very strict, very precise of how much that they have to reduce, but only for Annex 1 country. And then how about the non-Annex country like Indonesia? There's no cap for developing country like Indonesia, even China. So, in the continuation, so they were trying to continue Kyoto Protocol into Kyoto Protocol 2, but because of the lacking of common but differentiated responsibility, and then, there was very few countries who would like to be member countries of Kyoto Protocol 2. So that's why we have the Paris Agreement. Because in Paris, there's more of this common but differentiated responsibility. So it is every state's responsibility to reduce, right, the GHG emission. But how to reduce it, it's based on their specific capacities. So it doesn't, you give your own estimation of how much you can reduce. That's more palatable to develop and developing countries, actually. So like the developed country is not like burdened by themselves, while developing country is, making like factories and then open mining, etc., etc. Okay, so that's CBDR. And then there is this one. I think earlier we talked about, future. It's always talking about the future in IEL. It's intergenerational equity. Oh, before I go there, is there any question for CBDR? No questions? Okay, so we go to the right of future generation. Right? The right of future generation is the right for each generation to benefit and develop from the natural and cultural patrimony inherited from previous generation in such manner that it can be passed on to future generation in no worse condition than it was received. So it's sort of, giving the current state of the environment, if you can, better state of the environment to your children and your children's children. Like sometimes you don't think about it. Sometimes you think it's okay. Sometimes you think it's okay to take 30 minutes shower. It's not okay, right? We can lost water forever. Like, it's hard to have clean water now. And then you think it's okay to use plastic utensils in cafe and those rice bowls. I hate those stupid plastic rice bowls because they are not recyclables, right? You just put them in landfills and they stay there for 500 billion years. You will be dead for, 5,000 times, and the stupid rice bowls will still be there. Plus the aqua bottle. Oh my God. So I did a research with UNDP on plastic waste, and it turned out that most of the recycled bottles in Indonesia are not being recycled. So they are used for something else. So they reuse it for making apa tuh, aspal, or some are reused for something else, being cut very small and then use it as pallets for fuels in brick factories. But very few of them are recycling their plastic bottles like they say they would. So yeah. So don't use too many plastic bottles. Don't use plastic bottles at all. So usually I give extra credit for tumblers, but now that you're at home, I hope you're not using plastic bottles at all. Okay, before I get angry, let's go to the second bullet here. Each generation should be required to conserve the diversity and maintain the quality of the planet, and provide each member with equitable rights of access to the legacy of the past generation, and should conserve this access for the future generation. So yeah, so it's it's your responsibility, it's my responsibility, it's this generation responsibility, and the next generation responsibility to give it to the future generation, the legacy of what we have. So I mean, we currently already experiencing it and how hard it is not to being able to breathe without a mask, right? Well, not because the deterioration of the environment, but because of the virus. But maybe, one day it would be because of the air is not safe anymore. There are places that are already like that. If you go to New Delhi, for example, to India, big cities in India, Delhi and Mumbai, or even Jakarta, man. Jakarta is already like that before COVID. And sometimes COVID brings something good also. Okay, any questions for intergenerational equity? No? Okay. Okay, so basically in international environmental law, these principles are being adopted in different types of international law instruments, right? I'm just like listing it here, but you can have more of them, including the Paris Agreement, for example. So like UDHR, ICSCR, ICCPR, ECHR, and all this, they have all kinds of international human rights agreements, instruments, right? And there's also economic and social rights, right? And civil and political rights. Like all these principles are, intermingling with one another. They interplay and also sort of give reassurance that, one principle cannot be standing alone without the other principles. So it's, although we are talking about international environmental law principles, but we also talk about other principles that help IEL principles to be implemented, right? So everything is interdisciplinary. Nothing just stands out on its own. Okay. Any questions, you guys? Any questions on the principles? Okay. If there's no question, I'm calling on Felicia Ivana. Are you there? Felicia Ivana.
Can you hear me?
Yes. Okay. Hi, Felicia. Can you
Okay, so
explain to us the Lake Lanu case?
the Lakeland case. Okay, wait, ma'am. Let me open my file first. First of all, ma'am, I'm really sorry if it's a bit noisy. I'm not at home right now.
Hmm. Where are
Okay,
you?
I'm at the district court, ma'am. I'm doing an internship right now, and I already asked my jaksa so I can do attend my classes, so it's
Okay.
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 Okay, so the Lake Lanu case, the parties are Spain and France.
Mm-hmm.
So this is an arbitration case, and it is about the use of waters of Lake Lanu,
Mm-hmm.
which lies on the southern slopes of the Pyrenees of French territories. So, long story short, the French government proposed to carry out certain works uh, for the utilization of the waters of the lake.
Mm-hmm.
However, the Spanish government was really concerned that it would give a huge impact on Spanish rights and interests, contrary to the Treaty of Bayonne between France and Paris in 1866. So basically, they don't want France to use the water. They concern, if I'm not mistaken, it's gonna dry out. But
Mm-hmm.
France promised that we will give your water back, but only to the quantity that they needed, not all of them.
Okay.
Okay, so and then okay, wait a minute, ma'am. So then in yes, so France agreed to return the waters that had been diverted with the quantity of the actual needs of the Spanish users. Moreover, it is stated in the arbitration treaty of 10th July 1929 that the French government justified in its contention that in carrying out without a preliminary agreement between the two governments works for the use of the waters of Lake Lanu on the terms laid down in the project and in the French proposal mentioned in the preamble of this compromise. It would not commit a violation of the provisions of the Treaty of Bayonne and of the additional act of the same date. So the tribunal also stated that in this case, France has maintained to the end the solution, which consists in diverting the waters of the Carol to the, I don't know how to read it, Ari, Carol, Carol to the
Ariège.
Ariage
Uh-huh.
with full restitution. And then by making this choice, France is only making use of a right. The development works of Lake Lanu are on French territory, and the financing of and responsibility for the enterprise fall upon France. And France alone is the judge of works of public utility, which are to be executed on her own territory. Okay.
Okay. So thank you. Thank you, Felicia. I will call upon. I'm now calling upon. What's his name? Jeremy. Jeremy, you there?
Hello.
Yes, Jeremy. Can you explain to us the principles that exist in the Lake Lanu case?
Um, uh, I think the first principle is the territorial sovereignty.
Mm-hmm. Why?
Uh, because I think the Lake Lanuk is flowing from the France to the Spain territory, and it is mentioned that all standings and flowing waters are subject to the sovereignty of the states. in which they are located. So it means that the Lake Lanuk is subject to the sovereignty of Spain and France.
Okay. The second one?
The second one, I think it's about the principle of good faith.
Mm-hmm.
Okay, it is mentioned that France is promising to return the same amount of water that has been diverted toward the River Carol. So it is, as long as the additional act to the boundary treaties is not violated, it is not a violation toward the rule.
Okay. Thank you, Jeremy. Now I'm calling Owen. Owen, are you there? Owen.
Yes, hello, Mbak. Sorry, Mbak. Yes.
Okay, Owen. Can you elaborate more principles in relation to Lake Lanuk?
What I write in my extracurricular assignment is that I have three sovereignty rights over natural resources, which is territorial sovereignty, as mentioned before, and also principle of cooperation, because both countries are required by the tribunal to cooperate in good faith in resolving the matter.
Okay.
And also the last one is principle of good neighborhoodliness again, which is because France is obliged to respect Spain's rights to have their waters unaltered.
Okay. So what do you think the significance of the case, Owen?
Well, what I read is that it is vital for international environmental law because it contains the transnational possibility of harming the state, which is harming the state's water being diverted by other countries for their own personal use, and without them actually compensating enough or maybe like returning that water to its original quantity to the Spanish government. I think this is significance.
Okay. So, Lake Lanuk is a landmark case. So, when you're studying international environmental law, you will see both the case that we discussed today, nuclear test case and Lake Lanuk case, because both exemplify the importance of good faith, good neighborhoodliness, and also the possibility of transboundary harm. So if there's transboundary harm, who will be responsible, right? We will talk about specifically transboundary harm in another meeting because we will talk about the trail and smelter case later on. But this two specific case is giving you sort of like an idea how the principle of environmental law are in play. Like what do they do? In nuclear test case, most importantly, and also, well, actually in both cases, giving the example of how a country is acting on good faith. And in nuclear tests, even though the case was not even resolved at that time, France was giving a unilateral press conference, and then they sort of like saying like we'll stop all of this, you know, even before the case was finished, like it was still in proceeding, but France was giving out press conference, giving out statements to, not specifically to Australia and New Zealand, but they are just, you know, giving the self out there to the world and say we will stop our nuclear testing in the specific place. So in that specific case, it was sort of giving a clue on how international law are dealing with unilateral declaration. So even though the declaration was not directed to the other party, in this case, New Zealand and Australia, but France was giving unilateral declaration that they will stop whatever it is that they are doing, and it was accepted by the court also. Even though they didn't give it to the court, the declaration, there was just, you know, it was just an open declaration. but unilateral declaration was accepted. That's why they decided not to continue the case. Okay, so next week we will talk about IPCC, and hopefully it's a guest lecture week. So Prof. Edwin Aldrian is an expert on climate science. He is member bureau of the Intergovernmental Panel on Climate Change. So I asked him to share his experiences with you, which I hope it would be very interesting. So I'll see you next week. If there's any question for today, if there's no question, I'm going to close the class. Thank you so much, guys. See you next week. Maybe we'll use Google Meet again, because I see there's more stability in Google Meet in terms of the internet bandwidth. Okay, no questions?
No, Bu.
Okay, I'll see you next week. Wassalamualaikum.
Thank you, Ibu.
Thank you,
Thank
ma'am.
you.
Thank you, Bu.
Thank you.
Thank you,
Terima kasih, Bu.
Bu.
Thank you, Bu.
Makasih, Bu Linda.
Thank you, ma'am.
Thank you. Halo Ardi. Halo Ardi.
Hey.
Hey.
Uh,
Gimana kuliahnya, Di? Gimana kuliahnya, Di? Masa IEL tadi?
Ya, enak sih.
Halo Ardi, kangen.
Baik.
Ih, hafal dong. Ya udah, bye, Di. Semangat ya kuliahnya, semangat nugasnya.
Lu juga, Di.
Semangat.
Yo.
Ya udah.